The straw is in the drink. Good morning, friends. Welcome to Donna Adelson's final pretrial hearing before her jury selection begins next week on the 17th. Yeah, I think she's got one more opportunity after this to declare that she'd like to take a plea deal if that's offered from the state. But I don't see that happening. Must suck when you're 74 years old on a murder charge, and even the plea deal is like, well, I'd still be doing 10 years, which I would take, compared to what is almost certainly a guilty verdict and a life sentence mandatory. I would take 10 years, but the thing is, in 10 years, I'll be dead. So it's basically the same as taking your chances, right? Kind of funny, kind of what a situation to be in those golden years, in those golden years, that final chapter. Could be down playing shuffleboard on South Beach, maybe a trip to Yardbird with the grandkids for chicken and waffles, but no. Chemical mashed potatoes, and that's only at Christmas. Chemical mashed potatoes for a special occasion. Yeah, that's pretty much it, Donna. But we're not out of the woods yet, guys. We're not out of the woods yet. We're going to be seeing some more theatrics as Donna Adelson takes the opportunity for her last dress rehearsal in court, putting on her best sad, forlorn, frail, old. Yeah, she seems to have been practicing that face, Daniel Rashbaum, scalp rash. Mr. Morris and Mr. Rashbaum, scalp rash, must have said to her, listen, Donna, the insolence and the defiance, it's got to go. We can't have that in front of the jury. If you show insolence or defiance in front of the jury, it's done. We need to practice your forlorn, frail, harmless, old woman face, which is probably helpful because her face is pretty much falling off with all those chemicals just drooping like a basset hound. She looks like a basset hound now, right? Man, it's been a long road, Donna. You remember a while ago when she showed up on video chat for a hearing, and Judge Everett, for a microphone test, said, "And Miss Adelson, please tell me the name of your high school mascot." I love those questions when they come out of nowhere like that. And Donna couldn't remember. She looked pretty chirpy and happy. Remember, we were all saying, oh, maybe she's found peace in jail. Well, that's gone. Hey, did everyone check out STS's broadcast last night with Yindra and Ryan Fitzpatrick? Because True Crime Metrix got an honorable mention. Hey, we've got Yindra in the chat this morning. Good morning, Yindra. Welcome. Yeah, good show last night. I normally don't watch STS, but someone got in touch and said, you were just mentioned. So I had to go back and have a look. And yeah, it was great. And I was glad to hear that Ryan took it well. I'd forgotten all about that show, but as it was in context, I went back and watched my own show of Ryan Fitzpatrick, and I actually felt a little guilty. I felt like I might have overstepped with the, it's all well and good ripping on a criminal. They got where they are. I'll rip on Charlie and Donna all I like, but Ryan's done nothing wrong aside from that fucking haircut. But I thought no, but I was glad that he took it well. And yeah, Macho Sapien. Feel free to borrow that, Fancy Fiction, but remember to give me credit because that's mine, okay? Hashtag Macho Sapien. Yeah, I think we'll have a little merch line coming out with Macho Sapien. Going to be thinking about that over the weekend. So thanks a lot, Ryan. Yeah, and I enjoyed the show. And where are we now? We've got 5 minutes to go. 5 minutes to go. How's everyone doing in the chat? Welcome, everybody. Annie G, Brian Faircloth, Amy. Everybody's here. The whole gang. 3 cents. Good to see you. Good to see you. Maybe we should stick this stream on just to warm up, to get this puppy warmed up. How's the weather, guys? Present, share screen, browse. All right, we are rolling, guys. Look at that. Look at that. Stretch that out over here. Make it a full screen puppy. Why is it not? Oh, it's because it's not playing video yet. Okay, we have to wait. Don't worry. Don't worry. We're here. It's not going no place. Borrowing the video, the live video from Law and Crime Network, link in the description to their channel. I'm sure there's a bunch of content. And they've only got 453,000 subscribers, so they probably do need a plug from me. Yeah, what else is going on? Usually we read out some court docs here, but I haven't seen any yet because we've been so busy in the Metrix studio. Man, it has been a busy. There's just such a list of things to do. Fine and Dandy. Okay, yeah, Fine and Dandy Inc. Good to see you. Derek, good morning, son. Kosher Style. God, yeah, good turnout this morning, guys. 73 already, and we haven't even begun. Clarissa H. Good morning to you. Ryan slander will not be accepted. Yeah, we love Ryan. We love Ryan. And even more so because he can take comments in stride, you know? Take comments in stride. I really respect that and admire that. And it was great to see him along with you, Yindra, on the show last night. Love the glasses, by the way, Yindra. The huge glasses. Fantastic. Did you borrow them from a giant? Ryan B. Fantastic. Good to see you. Yeah. No slander, Ryan. On any Ryan. Every Ryan out there is now protected by Metrix. You want to get to them, you got to come through me. Wow. Okay, 2 minutes to go, guys. Do you think they're going to be on time? Judge Everett is having that all-important final bite of the... What's he having for breakfast this morning? I'm thinking 4 fried chickens, whole, and a Coke. Love Judge Everett. You know, we do rip on people, but most of the time, unless they're on trial for murder, it is done with absolute love. And, you know, it's just like a little miniature roast, you know, it's just all part of the fun. And we absolutely adore Judge Everett on this channel and General Isom and the whole gang, you know. I mean, obviously our Georgia Kappelman worship is palpable, and we have begun breaking ground on the shrine in Portugal, 50 feet high statue made of a special material, synthetic copper, but it looks just as good. It's just more environmentally friendly, which I think she would support, you know. And Georgia Kappelman, if you're ever in Portugal and you want somebody to show you around, look no further. Metrix will be your guide. Free of charge. Marion Emmanuel, how's the Brooklyn Bridge doing? You paying the tolls? Are there tolls? Probably not. Oh, it's 8 o'clock in the morning. So I always panic if they're like, oh, here we go.
Good morning. Yes, Judge. Mr. Beer will be appearing by Zoom.
Right, for everyone who is just added in the Zoom, please keep your devices on mute until your case is called. All of the other regular business of Division C will be handled before we get into the Adelson case. First up will be Christopher Beard, 2023 CF 1694. Mr. Beard, if you can turn on your video and audio, please. Good morning,
Mr. Beard. We've got Mr. Beard, Mr. Scalp.
Mr. Beard. Good morning. Ms. Fernandez.
Yes, Your Honor. I did file a stipulated motion to continue on this case. I'm asking for the 1st December docket time, please.
Right, I believe I granted the motion yesterday to put on case management for October, but you're just asking for December docket
October
setting.
might be best.
I'm fine with that, Judge.
2 steps forward, 2 more back. Are we sure what you want?
I would like the October case management. There are things that we are waiting on. Talk to the state, and that should happen by the end of September, and that will help us determine the best trial date.
All right. Concerning the issue of whether or not any depositions need to be taken, is this part of the matter?
That is part of the matter, Your Honor.
Very well. October 16th at 9 o'clock. New trial date to be set at that point. Mr. Beard, you're to remain in contact with your counsel, so that way you are aware of when any trial date is reset. Do you have any questions, sir?
No.
That concludes your appearance. Have a good day.
Thank you.
Let's move on to Shanika Butler-Geary.
Your Honor, Ms. Gary is present. For this case, if we can set this for, I also filed a stipulated motion to continue, and what we're essentially asking for is this to be set later on down the year. It could be a docket sounding in December, but I anticipate potentially just in the future trying to set a sentencing date. So if we can do November case management, that would probably work.
Ms. Jacobs, do you need to be
I love that we get a freebie before the real show starts.
heard on the matter?
No, Your Honor, that's fine.
11/13 at 9 o'clock will be the next date. At that point, if we need to set either for disposition or another matter, please let me know at that time.
Yes, Your Honor, thank you.
That concludes your appearance, ma'am. Mark Cleveland, 2023 CF 1820.
Michael Clark on behalf of Mr. Cleveland. Mr. Cleveland is present and approaching the podium, Your Honor. We are ready for trial. We'd ask to remain set.
Ms. Jacobs,
That's fine, Judge. We can leave it set.
is there any change in offer that needs to be discussed this morning before we proceed?
No, sir.
Very well. Mr. Clark, is there any offer that your client wishes for you to convey to the state?
No, sir.
Then this matter will remain on the trial docket. Since your client is out of custody, he will have a lower priority, but we'll determine the order momentarily. Please take a seat for now, Mr. Cleveland. Donald Culler.
Good morning, Ramble.
Amanda Balch on behalf of Donald Culler. We're ready to proceed to trial.
Right, Ms. Watt.
Just take us out of Your Honor.
What is the final offer that's been extended to the defendant?
15 months COC.
Ms. Walter, was this offer conveyed to your client?
No, Your Honor, we never received the offer. I can convey it to him and he can read it.
We'll readdress you in a moment. Well, actually, please stay for Vantavian Dawkins, and then you can speak to Mr. Culler. Is Mr. Dawkins present, or is he appearing by Zoom?
I believe he was going to appear by Zoom, Your Honor.
All right, I do not see him in the way.
I think I saw some of these defendants in the Leon County arrest photos the other day when we were getting Lewis and Katie's pictures.
Waiting room.
Your Honor, he was ordered to be here in person. We've been trying to roll his prints for the charge, and Your Honor ordered that he be here today.
I
Last
don't
year.
recall that. I recall him being ordered to be here in person for jury selection, and I represented to him that he did not have to appear today.
Yeah, hit the like, guys. We got 112 in the house already. Let's get those likes.
Okay, so if he's not here, that is not. on
Judge,
the
I brought this up at the last hearing. You ordered a mandatory appearance.
All right, he's not on the Zoom either. Please give him a phone call.
Yes, Your Honor.
He is going to need to appear through Zoom, if not in person. Archie Dill.
Good morning, Your Honor. Alex Mooney on Mr. Dill's behalf.
Good morning.
We're ready for a trial on the case. We have an outstanding motion to suppress to be heard on trial day, but we're ready for trial on the case.
Is this concerning the stop or the testing or what exactly?
It's concerning the stop in the case.
Ms. Watt,
Your Honor, the state's ready for trial.
what is the final offer that was conveyed to the defendant?
It's a global on 3 different charges. I guess you know.
Ms. Watt, get in front of a microphone. They can't hear you.
We gave an offer of adjudication of guilt and cost for the refusal, and then a misdemeanor for the DUI, 12 months probation with standard DUI conditions.
Was this offer conveyed to your client
It has been, Your
and the offer is rejected?
Honor, at this time.
Mr. Dill, please raise your right hand, sir, so you can be sworn. Do you swear or affirm the testimony you will give today will be the truth? You can lower your hand. Please stand in front of the microphone so your voice can be properly heard. Mr. Dill, do you understand the state's final offer that has been extended?
Yes, sir.
You are rejecting this offer.
Yes, sir.
Do you need any clarification from your attorney concerning this offer?
No, sir.
Do you wish for your counsel to make a counteroffer to the state to resolve this matter?
No, sir.
Very well. This matter will remain on the trial docket as well. I believe because this case is from this year and Mr. Dill is out of custody, he will fall lower on the priority, but we'll determine who will be tried momentarily. Please take a seat from now.
Thank you, Your Honor.
Damian Donahue. Not for a few minutes, and then we'll come back to Mr. Donahue. Dwight English.
Judge, I believe you signed an order continuing this for plea hearing.
I believe so as well.
It's going to be a DPA.
Yes.
And I did waive Mr. English's presence. He was out of state. He has to mail back in his paperwork and money order for the deferred prosecution agreement.
Right, thank you.
Yeah, right, Leslie. He didn't want his attorney to make a counteroffer. Why not? Just make a really, really good one.
Eric Garl. I believe this has already been continued as well. Saw Mr. Williams moving around. Mr. Williams.
What happened? Cameraman's forgot to put the tape in. I guess they don't use tapes anymore, right? See, when I was coming up, it was all on DV cam. Now it's probably just SD cards, internal memory. Yep, look, little SD card symbol. Slot B. Well, it's not going to be not guilty kosher style, but, you know, they're aiming for a hung jury for sure. That's based on sympathy. They want to turn, the defense want to turn at least one person and just have them not be able to send an old lady to jail forever. That's the play here. They want Donna facing the jury. They want everyone to get a good look at her. Donna's been practicing her innocent face. I'm an old lady who wants to play shuffleboard. You know. And probably being Harvey Adelson's primary caregiver is going to fall into it as well, you know, which is another reason I don't think Harvey Adelson's going to be showing up. They can paint that picture. If he's there, the picture is limited, right? He's probably been instructed not to show up if he was even thinking about it. What is going on here, guys? We've got to hear from Mr. Donahue and Mr. English. It's not what I signed up for. Hi, Kim. And what is with this name, Kim? Wend San A. I'm not totally sure I get it. Café con leche. That's dedication for you, Yendra. Streaming from Whole Foods. I think we should broadcast from the supermarket. We will do one day. Or the beach. Why not the beach? Well, I would be promoting law and crime, but they've dropped the ball. Oh, now we got color bars.
So I will rule on those matters before the trial begins.
Judge, I saw an order you entered. I saw Mr. Stevenson's motion in limine when this was set for trial way back, and you did file an order.
Two issues were reserved. Some of them were ruled on, but two issues were reserved. I believe this concerned the use of the deep web, or I forget the name of what it's called.
Here it's called a mer de late.
Thank you, sir. The use of the dark web, and I believe something else about communications with individuals in South America. If the parties have any additional arguments to make that were not already made, you're also entitled to pull your own copy of the recording of that hearing from that date as well.
Yes, sir.
Mr. Harrison, do you have any other motions that you anticipate need to be heard before the trial starts with Judge Long?
Yeah, kosher style, but technically she can still sue people from jail and prison. So at least she'll have something to do.
No, sir. I had a discussion about that with the client today, and he had indicated that I needed to file additional motions, but I understand the subject matter and I can handle that by a contemporaneous objection at the trial. In other words, before the evidence is offered by the state. And I've discussed that with the prosecutor, so there won't be any surprises there.
That is how the issue is preserved on appeal. You are well aware of this. Very well. You remain set for next week. Mr. Hastings, that concludes your appearance for this morning.
Judge, I'm gonna put on the record.
Can I ask one more thing, folks?
Go ahead.
Just to make sure we don't have any slip-ups. I've asked Mr. Hastings about court clothes, and he assured me that he has court clothes. If he doesn't, I'll go get him some. But I would just like, maybe you could inquire on that issue.
Do you have a friend or family member that can assist with this?
I don't. I do have court clothes, but I don't have a belt or a tie.
I'll bring him a belt and a tie, Judge.
All right. If you can tell Mr. Harrison your waist size, so that way.
Yeah, I guess he had to sell his belt and tie for that nickel bag. Okay.
The clothes won't look weird or ill-fitting. That'll be best.
And Judge, I'm gonna present counsel with the notice of intent to seek HFO penalty in open court.
And I've discussed that with the
How about some psychedelic suspenders?
defendant, and I'm well aware of the matter. Thank you.
Please step over to Mr. Balboni. He will take your prints at this time. Christian Henry, 2022 CF 3544. This matter was handled by written order. It has already been continued, I believe, to November. Steve Lincoln.
Good morning, Your Honor. John Stevenson representing Steve Lincoln. He's on his way over. We'll be ready to go on Monday. I did file a motion in limine last night. Assuming the state is going to present the information which you ruled inadmissible, but the first DCA disagreed with you, then most probably we will be doing a self-defense argument. And just reminding everybody that in a self-defense case, we are entitled to bring in any previous violent behavior by the alleged victim, which the defendant has knowledge of.
Ms. Jacobs.
Judge, I believe Mr. Stevenson just filed this motion in limine last night, so I haven't had a chance to look at it. I assumed Judge Gary, or Judge Long, whoever's going to be doing the trial, I assumed it would be Judge Gary, would be the one handling the motion in limine, because obviously I need time to look at it and do my own research. Otherwise, the state's ready for trial. With the caveat of how this afternoon goes. I know we have those motion hearings set this afternoon,
Very well.
but I anticipate being ready.
As to any matters that the DCA has previously ruled on, no further appeals were taken, correct?
I don't know any way I can, that they address the issue, so I'm stuck with it as far as I'm concerned.
As jurisdiction stacks, their ruling is their ruling. Act accordingly. Mr. Lincoln, you will.
Oh, man. Come on, Law and Crime Trials. What's going on, Law and Crime Trials? Hey, is Neety here? Where's Neety? Neety! How you doing? Welcome back, Neety. It's been too long. Well, this video is unavailable, but why? Why? Is it the cameraman's fault? Is it Judge Everett's fault? Oh, there's 16 minutes late for Donna's hearing. Giving Dan Rashbaum that extra bit of time to wash his hands. Man, use some soap on those hands, Daniel Rashbaum, please. Ramble says, Court TV and Law and Crime have to provide a link of stream to anyone that asks because they're the pool cam operators. So you can ask them to give you a link. Well, I just took it. I took it from their YouTube channel, but I do give them credit. It's mentioned in the description, the original channel and the link to the original video without Metrix comments. But, you know, let's be real. Who wants that? But you never know. They might have other great stuff on there. Good channel. Good channel. Of course, they get paid. Well, we're just going to hang out and chat then, I guess. Or should we try another? Do you think they've fucked it up? Do you think we should abandon ship and go and get another network? I don't know. It's the nature of live. Cameramen get drunk every night, kosher style. Sometimes on a beach in Nice, drinking absinthe. And then go straight to work after being up the whole night. It was great, though. I had 2 subordinates working for me. And I said, right, this is what you're going to do. You're going to do all the job on your own. I'm going to lie down behind the chairs at the back. I need to take off my shoes. Almost missed our plane home, too. It was a rough night, rough day, rough morning. Video unavailable. This is a joke. They're making me look bad. This is Law and Crime's fault, guys. Law and Crime Trials. Living Free 33. Hi, Kurt. Good to see you again, man. Glad to have you back. Justice for Dan Markel. It's coming. It's coming. I don't know. I'm thinking they've blown it. Maybe, what if Donna's on right now? How would we know? What to do? What to do? What other mainstream network covers this? Are the Tallahassee Democrat doing it? No. It's just the one camera in there, right? Who is John Wesley Holmes? Everyone says welcome like he is famous. Curious. What is that? Someone in the chat? John Wesley Holmes? John Wesley Snipes? Yeah, if you find anything out, Amy, let us know. Or maybe I should look for another feed. Let's have a look. Right, we can't rob Fancy Fiction. Hey, we're not that far behind you, though, Fancy, with the numbers. We're coming up strong. Donna Adelson. Hearing September 12th. I don't know. It looks like maybe I should refresh. Says video unavailable. It's set to private. Why is that? So it's down on all channels. Well, that makes sense. Maybe there's too many people re-streaming it and it's broken the internet. September 12th. What are people saying? Oh, mentor lawyer. Okay. Ah, fucking hell. Deep dive true crime.
As far as we can tell, it's going. He's rejected, Mr. Bolton's rejected probation. So, additionally, Your Honor, we do have the logistical issues. So, if the court does grant our motion to continue, we would request to be actually, as opposed to being a backup, simply because of the travel, that we actually be placed on the trial docket so that we make sure that we're going. So, logistically, we don't have to worry about the travel issues.
I think the best way to ensure that is whatever this is set again, ultimately for you to file a demand, and you will have top priority at that point. Ms. Jacobs.
That's fine, Judge. I don't have an objection. Obviously, if defense counsel isn't available.
Look at her peeking behind the post. We can see you, Donna.
I have communicated the offer to Mr. Myers, not to Mr. Shepherd. I do want to put that on the record since the defendant is present on the Zoom, because
Go
I
ahead.
do also want to give a cutoff date to that offer at this point. The last offer that was extended to the defendant was for him to enter an open plea as charged, which is manslaughter by driving under the influence, that the state would waive his score sheet, which is 10 years in the Department of
Absolutely shout out to Mentor Lawyer for having the backup,
Corrections, but not
the backbone.
the minimum mandatory, which is 4 years in the Department of Corrections. And so your honor would have a sentencing range of between 4 and 15 years in the Department of Corrections. The cutoff date that I'm going to give to this defendant to enter that plea is October 16th.
Well,
I'm not sure that that offer has been conveyed to Mr. Norwood. I think that maybe that's a very recent offer.
I've repeatedly given it to Mr. Myers
Maybe he
over the
has,
course
Judge.
of
My
months.
apologies.
So I don't know if it's been communicated to the client, because obviously I'm not allowed to talk to him, but I've given it to Mr. Myers multiple times.
Mr. Norwood, were you able to clearly hear Ms. Jacobs when she conveyed the offer?
Yes, sir.
You will have some additional time to discuss the offer with your attorneys in private, but I wanted to make sure you are aware of it, and you're also aware of the cutoff date, which again would be 10/16, Ms. Jacobs.
Yes, your honor.
Very well. This matter will be reset to docket sounding on October 17th for the trial week of October 21. To ensure that you are in fact going as requested, the defense should file a demand for speedy trial. And at that point, there will be no question.
10-4. Thank you, sir. Appreciate you.
Have a good day, Mr. Norwood. You are excused.
Thank you, Your Honor. That concludes my business.
Karina Robinson. Good morning, Ms. Robinson.
Morning.
Ms. Robinson, at all critical stages, the court will offer you court-appointed counsel once again.
What's that, Amanda? There's another angle or something?
Through a Feretta hearing, you are representing yourself. As I found, you voluntarily waived an intelligence.
Yeah, if anyone knows like a wider angle, let us know in the comments with a link, please.
Waived your right to court-appointed counsel. Do you wish to have court-appointed counsel appointed to you once again?
No, sir.
Very well. You will continue to represent yourself. I will rely on all findings and representations that were previously made at the Feretta hearing. Ms. Robinson, are you prepared to go to trial?
Your Honor, if we could get one cycle continuance on this,
Are you prepared to go to trial?
and I think we'll have a resolution by mid-October. We're pending a DCF mental health eval, and we'd like to see the results of that before we can pay a final offer.
Was she previously offered diversion on this matter?
She was previously offered a DPA and denied it.
I don't think there's anything else to
No.
offer.
Well, we revoked it, and we are considering giving her the DPA once again if the mental health shows us differently.
Very well. Ms. Robinson, do you understand what the state is asking for?
Yes, sir.
Very well. I will continue this matter. What date are you asking for in October?
Yes, Your Honor, docket sounding 10/17, I believe.
October 17th, docket sounding, week of trial would be 10/21. Ms. Robinson, you are to appear in person once again. Have a good day. Metrix Sailor, demand for speedy trial, 2024 CF 1397.
Thanks for the super chat, Amanda. And don't worry about it.
Hey, good morning, Judge.
Good morning. What date is the defense requesting? We're still within natural speed, are we not?
Honestly, I'm not sure. I filed the demand. I think we are.
My system is showing the case is 57 days old, but at this point, the defense is fully ready. You don't need anything else.
Yes, sir.
Mr. Fields.
Judge, I am not available on the October dates. I did discuss this with Mr. Fuchs. It could be reassigned if Your Honor is inclined to set it in October, but I would request November.
What is the October date?
Well, the first
Nice one, Leslie. Go for it. Give it all you got.
available week would be 10/7 with a 9/26 docket sounding. But you're unavailable, Mr. Fields, that week.
The 7th for sure, and I'm coming back like in the middle of what would be the prep week for the 21st. So I prefer not to load that down. Also know that I think Ms. Dugan has a murder trial that week too. So we've been trying to avoid setting things.
Oh, thanks so much, Leslie, for the super chat in honor of first peek at Donna behind the column.
Anything on the 21st if we can.
Right, there's 10/31 and then the 11/4 trial week. I believe that still falls within the 175-day period, unless you have a different calculation, Mr. Williams.
I'd have to recalculate the 175, and to be honest, Judge, I've never been in a situation where I've filed demand within natural speed. So I don't know.
45 days from the demand still, but
So if we're going off that date and not natural speed, I believe, and I know we have a recapture period. I believe the recapture period is now 30 days. But I'm calculating, the case needs to be set before November 2nd.
Hey, Miss Cakes, I don't know if you noticed, but we're streaming it too. Why are you promoting other channels?
So if, to the extent we're setting it November 4th, I'd object in the sense that it's set outside of speeding. But again, I know the state has a recapture period.
That's all right. You can go and see deep dive true crime and fancy fiction if you like. You'd probably learn a lot more there.
I don't want to waive speedy by setting it outside of speeding to that extent.
well, you're still within natural speedy. All you're doing is demanding to get to the head of the line. Mr.
Hi, Carrie.
Fields.
Judge, if we're within natural speedy, I would still ask for November.
But and again, I haven't researched this issue, but if I file a demand, I believe the demand will control.
All right. As to any conflict between the demand and natural speedy, I'll have to admit I'm rusty on this issue. For now, I'll set on 10/31 and 11/4. If there is conflict between the two, we will readdress and set it during the proper time.
Understood. Thank you, Judge.
Christine Stewart.
Yes, Your Honor, she's not present today,
Have you had any prior contact with Ms. Stewart?
prior to the last episode.
Very well. I do not see her in Zoom as well. Cavius Novan, failure to appear. Michael White.
Your Honor, I filed a motion to continue in this case. I would like to approach about.
Please approach.
Yeah, I just checked Roberta's channel. She's using the same video we are. Man, I'm surprised Judge Everett's letting it slide like this. He's usually Mr. Punctual.
Joint motion to continue is granted. The next court date for Mr. White will be October 15th at 9 o'clock in the morning. Any trial date to be reset at that point.
Thank you, sir.
All right, Van Tavian Dawkins.
Yes, sir.
Good morning, Mr. Dawkins.
Good morning, how are you?
I'm doing well. Mr. Dawkins, I know this is Zoom, but you're still in court. Take that hat off.
Oh, love it. Take that hat off, Mr. Dawkins.
Sorry. I apologize about it.
Ms. Walter.
Your Honor, the defense is ready to proceed to trial. I know that Mr. Fields mentioned previously, before Mr. Dawkins was present on Zoom, that his understanding was that the court had ordered today to be a mandatory in-person appearance. I don't have any recollection of that. That is not what I advised Mr. Dawkins. It's not reflected in the clerk notes from his last court date. So that is why he's present on Zoom.
I remember the fingerprints were an issue that were discussed, but Mr. Dawkins also was dealing with a COVID diagnosis,
Yes, Your Honor.
in which that's why the trial could not proceed last week. Mr. Dawkins, you are going to have to be present come Monday morning. You are going to be
Hey, Miss Cakes, we're always thanking Fancy and Deep Dive.
one of the cases set for trial. At that time on Monday, one moment, at that time on Monday, your fingerprints are going to be rolled unless there is a lawful objection.
And
Ms.
I have no
Walter?
objection, Your Honor.
Very well, Mr. Fields. Hold on, Mr. Dawkins.
Judge, we're ready for trial. This is going to be tried by ASA panel Watt, and we'd request the Friday trial date.
All right, for now, Lincoln and, make sure I get the name correct, Hastings are going to be the primaries. Mr. Dawkins will be the first backup since this is a one day. Mr. Dawkins, you had a question? One moment, before you speak, I'm going to advise you, you have the right to remain silent. Please do not discuss the facts of your case, but I will allow you to speak if you choose to do so. Go ahead, sir.
Originally, Ms. Washington is my third public defendant. I never confirmed anything in writing or in word about going to trial at all. But I understand the circumstances.
Riding shotgun. We're using the same video as Roberta. I think maybe it's just at a different time. It's zoomed out here now.
How far things came, but I'm seeking a private attorney right now because it's just the situation just to me is just ridiculous. Like I've been attacked.
Mr. Dawkins, I know you're on Zoom, but you're still in court. Put that crack pipe down, son.
Every week, I go to work every day just like everybody else. And I got a private attorney that I want to put on the case because I never, not in words, not verbally or wrote anything, said I want to go to trial.
All right, Mr. Dawkins, at this point, this would be a bit untimely to have a substitution of counsel. I'm not going to tell you who to hire or who not to, but until someone has entered your case as private counsel, Ms. Walter, as your counsel of record, the case is going to move forward. Mr. Fields, do you have a final offer to extend?
Judge, I revoked my offer at the last court hearing. There's not been an acceptable counteroffer made from the defense. They're offering the same thing they were offering during intake prior to the motion to suppress. So at this point, no.
Permission to speak, Judge.
One moment, Mr. Dawkins. Ms. Walter, do you have any counteroffer that your client wishes to extend that has not already been rejected?
Not that I'm aware of, Your Honor.
Mr. Dawkins, you may speak if you wish to do so. Go ahead, sir.
I had no knowledge about the offer being denied. If, the state willing to work something out, I don't have any problem with that, but I don't have any knowledge of state denying anything.
This is to be settled, Mr. Dawkins, between your counsel and the state if there's going to be any resuming of a plea negotiation. Please appear on Monday at 8:30 in courtroom 3B. Be prepared to go to trial. Have a good day.
Oh, fucking hell.
Danny and Donahue.
Okay, this cameraman is fired. He forgets the tape. He forgets the battery. You plug into the wall, man.
Any previously entered plea.
Ugh. He better not do this during the hearing.
Sentenced to 36 months in the Department of Corrections with credit.
God, the fuck. Oh, nice one, Kim. Yeah, all you guys in chat should run over to the merch store and pick up your Don't Be an Adelson t-shirt. We will be releasing Georgia Kappelman specials along with some variation of Macho Sapien merch. I think it's going to be a hit. I mean, I could see those selling in Target, you know, for cheap, but still in a major outlet. Yeah. What else have we got? We've got you're either stupid or you're lying in the merch. Yeah, we got with our list of great merch is so long, it's just finding the time to put it together. But we'll get there. We'll get there. Yeah, what's the merch store? It's merch.truecrimemetrics.com. That's where all the merch lives, you see. We got cups, we got hoodies, we got t-shirts, we got there's even some baby clothes with the True Crime Metrics merch. What else have we got? We've got I forget, but it's all there. Merch.truecrimemetrics.com. There you go. Neville's got the link right there. Don't Be an Adelson t-shirts. A range of colors. But some people have said, yeah, love the merch, but don't want to wear Donna's face on my chest. And I understand that. That's why we're going to be hitting up with some Georgia Kappelman memorabilia specials. You know, we've got a great line of Georgia Kappelman. And maybe we should even do Sarah Dugan as well. Yeah, why not? They're both part of the legal dream team of Leon County, right? I've got to write to Ryan Fitzpatrick, though, and ask him if I can use his image. Of course, I will be sending him a free t-shirt of the Macho Sapien merch when we get to print. Okay, let's check out. Anybody see a live feed going on right now, or has Roberta and James, mentor lawyer, all got these color bars as well with the no signal fired? Go to the unemployment line, cameraman. Yeah, Carrie, there's also some pet-related merch available as well. I don't think we've set any up for print with the Metrix editions yet, but we plan to in the near future. Oh, cushions! Fantastic cushions. Also cushions, yes. Everyone is down, Leslie. Okay, thanks for keeping an eye on that, Leslie. You're really sharp on the details. You're like my eyes and ears, Leslie. 2020.
F3226.
Here we go.
Mrs. Adelson, you can go ahead and take a seat at council table.
Yes. She's brushed her hair today, so that's different.
In addition to the normal docket sounding business to address, we have the motion filed by attorney David Marcus to quash a subpoena by the defense And we also have the matter that we need to finish on Sergeant Corbett's testimony. Did everyone receive their copy of the order on the defense's motion in limine yesterday?
Yes, sir. Yes, Your Honor.
Very well. You may make your notices of appearance.
Georgia Kappelman for the state. Mr. Kappelman Jr. for the state.
Dan Rashbaum on behalf of Ms. Adelson.
Alex Morris on behalf of Mrs. Davidson.
Right, Mr. Marcus, I will be with you momentarily. Concerning our docket sounding this morning, let's go ahead and address that. Does the state have any issues that they need to raise at this time?
No, Your Honor, the state's ready.
Has the state extended a final offer to the defendant?
No, Your Honor.
Very well. Mr. Morris, Mr. Rashbaum, does your client have a counter offer that she wishes to extend to the state at this time?
No, Your Honor.
Mrs. Adelson, if you please can rise and raise your right hand. Please, do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. Mrs. Adelson, is there any counter offer that you wish for your attorneys to extend to the state before we proceed further in this matter? Very well, you may be seated. Is there any issue?
Kind of big moment there, huh, Donna? No counteroffer. So that's it then. No more offers. We're going to trial.
The defense needs to raise moving into next week.
No, Your Honor.
Then let's go ahead and address Mr. Marcus's motion to quash the defense subpoena. Mr. Marcus, good morning, sir.
Good morning, Your Honor.
Rashbaum has grown back his beard, but has so far only grown it enough to cover one of his chins. The other one is still bald.
You as well. I have reviewed your pleading. What is the defense's position concerning the trial testimony subpoena?
Judge, the defense doesn't seek to elicit any testimony related to Mr. Marcus's attorney-client protected conversations with his client.
Fuck, cunt. Sorry.
State's indicated and they reaffirmed to Your Honor that they intend to ask Investigator Isom whether or not Mr. Marcus called immediately after Katie McManua was arrested. The jury, if left there, the jury takes away that someone or somehow the defendants are all in cahoots, if you will. The defense believes that Mr. Marcus would testify that that is not the case at all, and he would provide information as to how it was that he received information about Ms. McManua's arrest and how he knew to call Investigator Isom. That's the first category. The second one is the state has investigated vigorously to try to pinpoint that the Adelson family has provided legal fees for other lawyers or other co-defendants in the case. I don't know whether the state seeks to elicit testimony of that nature, but as recent as January of this year, the FBI was down in Miami speaking with Mr. Marcus about such things. Mr. Marcus provides an explanation that doesn't involve attorney-client privilege that didn't happen. Mr. Marcus made a suggestion of the potential legal strategies involved, but nothing ever came to fruition, and there were no discussions with any co-defendants or the Adelsons. And then the third category, Judge, is there's a text message between Mr. Marcus and his client, Charlie Adelson, at the time about him having seen or bumped into Katie McManua outside of his office. And there's a comment about something to the extent of it being a coincidence, but there was no conversation that was had. Again, if the state elicits that testimony in all three of those categories and it's left hanging, it goes unanswered. But in each circumstance, Mr. Marcus is able to respond, and I don't believe that it invades the attorney-client privilege.
Mr. Marcus, I'll allow you to respond to what the defense is proffering and why they would seek your testimony.
Thank you, Your Honor. And so I'll take the easiest one first, which is the last one. I had not heard about this text message between me and my former client, but that would obviously be privileged. And so any testimony regarding a text message between me and Charlie Adelson, I would not be able to comment on. So that I think is the easiest one. Let me take the other two.
Let me ask you one question before you continue. Mr. Adelson has not waived any privilege with regard to you.
Correct.
You may continue.
Thank you. Yes, I have not been informed that he's waived any privilege by him or anyone else. The other two categories, and I'm sorry for not looking always at the camera, looking at my notes here, Your Honor, but the first is the call to Detective Isom. So I guess I just don't understand how the state putting in this evidence is relevant, and therefore the underlying evidence in my response to it, I think, should be suppressed. The idea that on the morning that Katie McVanival was arrested, I learned of that arrest and called the detective to find out if Charlie Adelson was being arrested. There's nothing wrong with that. That's what any good lawyer would do. The defense is right that I would respond to any nefarious suggestion by the state that there's nothing wrong with me calling the detective to find out if Charlie was being arrested that morning. But I guess my response would be, I don't think that initial evidence should be able to come in, and I made a phone call to the detective to inquire about Charlie. Certainly that has nothing to do with Donna Adelson. And even if this was a trial about Charlie Adelson, I don't think it would be relevant, Your Honor. I was trying to find out whether the detective that morning was going to arrest Charlie. Nothing's wrong, nothing untoward or abnormal about me calling the detective to inquire about that. So I would ask that whole little snippet be excluded, the underlying evidence, and what my response would be to it. The final thing about legal fees, I addressed this in my motion. I've spoken to the state about it, so I don't think they're going to elicit anything about this.
Absolutely, Scalp seems like a total lightweight, Derek. I don't know what he's doing here. I was actually worried when he first arrived. I thought this guy was going to be the hammer, but it turns out he's more like a balloon of nothing.
On this issue, so I'm not sure that the defense needs me to rebut anything, because my understanding from speaking to the state is they don't intend to elicit anything on that issue.
Ms. Kappelman, Ms. Dugan, are you seeking to elicit any information or evidence during the trial that would concern Mr. Marcus?
Potentially, yes, Your Honor. We are seeking to introduce the evidence that I mentioned previously at our last hearing about the call to Isom.
And the relevance hook of this would be, it goes your conspiracy theory, or what exactly?
Yes, sir. Exactly. Would I get into anything about the offer from Mr. Marcus to Catherine McVanival's attorneys to pay her attorney's fees on behalf of the Adelsons? Potentially, yes. And what's the third question?
I believe the last matter was any text message between Mr. Marcus and Charles Adelson when he was representing him.
Yeah, I think that the defense has mischaracterized that evidence, but that is a piece that could potentially be inquired about as well.
All right. As to the
So all of it then.
first issue of the phone call and whether it goes in any form or fashion to the conspiracy, what I'm going to rule is the following. The state may inquire as to the topic. If the defense has a factual related line of questioning to ask Mr. Marcus, the factual line of questioning will be permitted. Nothing that goes into attorney-client privilege may be inquired to. Is everyone clear on this?
Yes.
Very well. As to the second line of questioning, again, Ms. Kappelman, this is being offered for what exactly concerning any possible agreement or payment?
Yes, same relevance argument here that it goes to conspiracy, the existence of the conspiracy.
Right. As to this, were the defendants, well, I believe the privilege argument gets a little more thorny at this point. What exactly can Mr. Marcus offer that would not be privileged on this issue?
Are you inquiring to me, Judge?
Either party.
My understanding, and Mr. Marcus can correct me where I'm wrong, is that there was a conversation with Katie McManus' counsel, I don't believe that Mr. Marcus conferred with his client, but it's something that he does in his normal practices, which a lot of lawyers do, myself included, call co-defendants counsel. If there's a necessity of sharing expenses, I think it was his suggestion, and just that, his suggestion versus the Adelsons.
Marcus, is there any argument as to why this is privileged specifically?
No, Your Honor, if I'm asked the privilege question on the stand, of course, I'll just invoke it at that point.
I just had a thought, guys. I wonder if Donna Adelson is insisting on a kosher meal in jail because it might be slightly better than what's on the line that day.
I have no problem doing
Kind of dark irony, right?
that, Your Honor. Your Honor, if I could just be heard for 1 second.
Go ahead.
There is, of course, a difference with the state arguing the existence of a conspiracy and crazy conspiracy theories. There is no basis to argue the existence of a conspiracy by my calling the detective to find out whether Charlie Adelson was being arrested that morning. There's just no, they have to at least allege some tie, some basis in fact to argue that there was a conspiracy that would have some relevance in this trial. Your Honor, I was calling to find out from the detective whether he was arresting my client that morning. There's nothing tied to any conspiracy, certainly, with Donna Adelson. So it's just a conspiracy theory with no basis in fact, Your Honor.
I fully understand where you're coming from with both your pleading and your position this morning. As a factual issue, did the phone call take place? There is nothing protected concerning that. How that fits into the larger narrative of what may be admissible or not, yet to be determined. The state, they have their fair opportunity to put on their case. If further objection needs to be raised at that time, I will address at the time. But as to the pure factual issue and whether or not you have knowledge on that topic, that does not go to privilege. That is where they will be permitted to inquire. That is where the defense will be permitted to rebut. Nothing more, nothing further. As to the second issue of the offering of fees, is there any privilege that you can assert concerning this, or this was just an idea between you to the other attorneys?
The latter.
As to that topic, factually, it may be inquired into. How this again fits into the larger weaving of the evidence. If there needs to be an objection at that time, it may be raised, but on the pure factual issue, state may inquire, defense may rebut. As to the third issue of the text message between attorney and Mr. Marcus and Mr. Adelson.
I have my facts wrong on that, Judge. I'm sorry for interrupting. The message is actually, Mr. Marcus spoke with Mr. Adelson. Mr. Adelson then communicated with his mother that he had spoken with Mr. Marcus, and Mr. Marcus had indicated that he had bumped in to Ms. McManus. So my sequence of events is a little off.
And the state would be seeking to offer this also under the same conspiracy theory.
Yes, Your Honor.
Yeah, I think Mr. Marcus is Charlie Adelson's attorney before Daniel Rashbaum took the case.
Right. Mr. Marcus, are you alleging or asserting at this point that a privileged matter was discussed through that text message?
I don't know what text message they're referring to, Your Honor. I have not seen it, but if they're referring at all to a text message between me and my client, of course, that would be privileged. If I'm hearing Mr. Morris right, he's now referring to a text message between Charlie Adelson and Donna Adelson. I don't know whether that would be privileged or not. I doubt it, but I don't have any, that's not between me and my client and my former client.
Was this a communication that was captured through the wiretap?
No, sir. It's part of what was captured off of the devices that were searched.
So this was a text message
Oh, that's new stuff then. Looking forward to seeing that.
from Mr. Adelson to Mrs. Adelson.
That's correct, Your Honor.
All right. As to that, Mr. Marcus, if it does not include any advice or opinions that you're providing to your client, if there was no joint defense agreement concerning them, Ultimately, this can be argued as a communication between co-conspirators. It just merely mentions your name, if I'm understanding this correctly. Is there any correction as that needs to be given on this point? Okay.
No, Your Honor.
Very well. As to that, the state may inquire as to the communication, as to anything that Mr. Marcus discussed with Mr. Adelson that may not be inquired into, but the substance of the text message, the state in some way is going to argue this goes to conspiracy. They'll be given an opportunity to do so. If an objection needs to be raised, you may do so contemporaneously during the trial itself. So Mr. Marcus has a better opportunity to plan. The parties know when he would actually need to testify. I'm sure he has a very busy schedule, and we're not trying to create a hardship or inconvenience as it relates to his work and business.
As soon as the state rests, the defense intends on calling him.
Ron, I believe your previous estimate, Ms. Kappelman, was 6 or 7 days.
Yes, sir.
Let's pinpoint on the calendar then at least a projection that will assist the witness in determining when he would need to be present. Jury selection begins next week on the 17th. If we have a jury by Thursday the 19th, the first day of trial would be Friday the 20th. And that means by Friday the 27th, potentially the state is resting its case, which would lead us then to Monday the 30th.
We are going to have so much to talk about on the weekend, man. You know, if they do the opening statements on Friday and then they're not back until Monday, oh my God.
The beginning of the defense case, unless I'm off of my calculations.
You're correct, Your Honor.
You're correct. And the defense has a bit of a time pressure also because of the Jewish holidays.
Mr. Marcus, if you can go ahead then and mark on your calendar as to when you may potentially be called, starting with September 30th. If there is any hardship that you need to address in other cases or matters that you're involved with, please let the parties know. If it's another state court matter, perhaps I can pick up the phone, free you up.
Thank you, Your Honor. I am doing federal court on the 1st, but I'll work with the parties to see if I can respect, Your Honor, that when
What is going on with that beard, Rashbaum? Either grow it all or shave it off.
these factual issues come up in trial, that there will be some debate about whether these items should come in, because again, I'm not as plugged in as everybody here, but it just seems that the 3 topics don't go to any actual conspiracy theory, but I'm hoping that when the objections are raised, they may all be might need to come on the 30th.
All right. That concludes the motion to quash the subpoena. Have a good day, sir.
Thank you, Your Honor.
Did you actually hear that, Leslie? Donna saying to Dan, how could they do this? This is insane. No evidence. No evidence.
All right, let's continue next with the continuation of the motion on the summary. Is Sergeant Corbett present?
Should be judge on me.
And also, so the record is clear on this matter, the motion to quash the trial subpoena is denied as to all factual issues in which Mr. Marcus would have personal knowledge and can testify relevantly.
Yes, we have to postpone the trial because it's Yom Kippur. It's Yom Kippur coming up.
I could just send him a message. I'm sure he's probably parking or on the elevator or something like that. We do have we do have another part of the motion. If you want, we could take up in the meantime.
Sure.
They had objections to specific parts of the presentation as to hearsay and attorney-client joint
defense privilege. We could go ahead and take those up now.
Go ahead.
Mayor, first, Your Honor.
You may.
Judge, it's changing the document, so it's based on what I have so far. So there may be more that comes up in trial, but based on what I have right now.
You've reviewed it all, correct?
What's that?
You've reviewed all of it.
I've reviewed all that we have as of now.
Right, go ahead.
So I think it's page 20. It's an email between Donna Adelson and Renee Griggs. And below it, it's in response to an email from Renee Griggs to Donna Adelson. It's hearsay.
What is this being offered for?
Judge, in that email, the defendant explains that she is stressed about her daughter not being able to relocate. You know, that her daughter, I think, doesn't realize how much it will affect her life, Donna Adelson's life, their whole family's life if this doesn't happen. The comments from the counselor that are concerned about her stress levels, I think, just add context. That's what we would be asking for the whole email to be admissible for.
I don't know, Ramble. I only know that from the movie with Ray Milland called The Lost Weekend.
So you're not offering it for the truth of the matter asserted, or you're offering it as a party opponent admission of some sort?
Yes, we're offering Donna Adelson's comments as admission by a party opponent, also a statement against interest about how stressed she is about her daughter not being able to relocate and how much it will affect her family if it doesn't happen. The therapists, or not therapists, life coaches' comments that are also contained in the email would only be there for context.
Very well. As to that point, Mr. Rauschenbaum, I will permit slide 20 if there is any limiting instruction that you wish to give concerning Mrs. Griggs' responses as only providing context to what the admission may be. That would be appropriate. But if these are party opponent admissions, they are permitted.
Judge, may I briefly just respond and be heard?
Go ahead.
The problem isn't Donna Adelson's comments. We don't have a problem with that. Those are statements against interest, and they're not confusing at all. They say exactly what they just said. The problem is Renee Griggs.
They're not confusing at all, and they actually prove her innocence.
Is emailed to Donna Adelson, which is hearsay. It doesn't give any additional context to what she says. You can understand Donna Adelson's admissions by her email online.
So you're saying part then of this is just a response from Griggs to your client?
No, it's a chain, right? So it's a chain of emails between the two of them. We have no issues with Donna's part of the chain coming in. The problem is Renee Griggs' chain it's not confusing what Donna's saying. I can read it to you. She says exactly what they just said. So if you never heard what Griggs says, she says, "I'm stressed about my son, but honestly."
Is Renee Griggs the Renee that Wendy was talking about in the interview? Renee is a very close friend of mine. And if ever there was a woman I'd like to get a hug from, it's Renee.
I'm more stressed about Wendy and what will happen if she doesn't get relocation at the June hearing. Her life will change drastically if she has to remain in Tallahassee, and so will ours, and not in a good way. But I'll tell you more about it when we talk. Hope your mother is doing better, or at least stable, Donna. So if you just allow that in, which we don't have an objection to, that's a statement that Donna Adelson's making, you're okay. But
does Griggs respond from there? Does your client respond from the response?
No, Griggs doesn't respond from there, but Griggs' email below is, "Hi Donna, I'm not sure," and I only have part of it, "but I'm not sure if you're back from your trip yet or not. I planned to check in yesterday. However, my mom was in the hospital and I was handling family stuff, so I was a bit out of pocket. More than anything else, I want to see how you're doing. It seems as though you have a great deal of weight on your shoulders. I could both hear and feel it on our phone conversation the other day. I'd really like to be able to help you shed whatever it is that feels so heavy. Please know I'm thinking of you and looking forward to our work together whenever you're ready. Take good care, Renee." I don't see how that isn't blatant hearsay without any exception. It doesn't, you understand what, I mean, again, the relevance that they just put it in for.
Kosher style, this sentiment you're expressing here is exactly what they're looking for in the at least one member of the jury. Be careful, be careful. Remember, she's a murdering, narcissistic psychopath, and she really is where she needs to be.
Is exactly what
Donna Adelson is not your mom, okay?
Donna Adelson's email says, which we don't have a problem with that piece of it.
Ms. Dugan, what exactly context is being provided by Mrs. Griggs' first email before Ms. Adelson responds?
So the defense, I think, accidentally, when they read about, yes, I'm stressed about my son and my daughter, she doesn't get relocation and how all our lives have changed drastically. That was Donna Adelson's email. The last email he wrote was from Ms. Griggs. In that email from Ms. Griggs, who's the life coach, she basically is just saying, I'm checking in on you. You seem last time to have a great deal of weight on your shoulders. I'd like to help you. And that's when Donna Adelson talks about how stressed she is and how much their lives will change drastically. So I think that the life coach's email just gives Ms. Adelson's comments a little bit of context as far as explaining why she's kind of pouring her heart out there and explaining why she's been so upset.
How much further does this chain go beyond?
I'm not seeking anything more than this page. I think there is more of this chain, but this is the only page I'd be asking for.
I'll reserve ruling on this from now. I'll look at it again when I have my thumb drive and can review the slide in its entirety. Go ahead.
Judge, I think the next item we have, I think we've gotten new slides on this, but I'll go, I think for ease, we'll go on the slides that you have.
Hey, Leah, thanks for letting us know. Over 100 likes on the video, guys, but still room for another 20. Remember to like the video, guys. Let's push it up. Let's push it up.
Because it's the same issue. If you go, it slides 255. We don't actually have new slides on this. I apologize. It's slide 255, where Agent Corbett is estimating how long travel takes. We're moving to exclude that based on speculation.
Student did Sergeant Corbett do any?
Kosher style, they're talking between Donna and this life coach. Should be very funny to hear. Yeah, with some information that they're talking about now.
Calculation or in some other way develop this information that can be demonstrated as reliable.
Yes, sir. So
Thanks so much, Amanda, for the coffee. We just saw that come in. If anyone else wants to support the channel, you can find a link to buymeacoffee.com in the description for the video, and we really, really appreciate it.
on this slide, we have actual versus optimal travel of Wendy Adelson on the day of the crime. The actual travel is based on the events in her call detail records, where it shows the cell towers that her phone is communicating with as she leaves her house and goes on her way that day from by the crime scene to ABC liquor store and up to lunch. That's based on call detail records. And also other evidence like an ABC receipt that she had that day. For the red dotted line, that's the summary of the shortest route. So we're saying this is the actual route versus the shortest route she could have taken from point A to point B. Her home to where another liquor store is in the restaurant. What he uses to show travel time or miles is a company called, or a mapping company called Esri, which is, and if you need to hear more about it from Sergeant Corbett, he'll be here in just a second. But basically that is
we got Corbett coming into the house.
A software that Florida Department of Transportation uses for their mapping and mileage calculations. He uses this very regularly in all of his mapping and travel calculations in all of his presentations. it himself. He looks at where the map says the travel time should be in the miles, and he does the drive himself. So he's been able to personally test this several times, and it's been accurate. And what we have.
I love how Corbett is passionate about his job. You know, the weekend rolls in, and what's he doing? Is he going fishing? Is he going to the beach? Is he going to see the ball game? No, he's going to go and test the accuracy of the mapping software by driving the routes himself. He loves it.
In this slide is one is call records, the other is the summary of the shortest route, and it's literally just saying, hey, this is point A, this is point B, and this is the mileage according to Esri, and this is the minutes it should take. And it's twice as long as the actual, or twice as short as the actual route.
All right. The sergeant also would be able to testify as to his knowledge of this program, its use, and the fact that he is qualified to use this program.
Yes, sir, and I can ask him those questions today if you'd like me to, but he regularly uses this program and has knowledge of it, is qualified to talk about it, and has had personal knowledge of testing its accuracy before.
All right. On this issue, Mr. Rauschbaum, you're essentially objecting that either the sergeant does not have an accurate calculation or in some way misuses the program. What exactly are you getting at?
May I have one moment, Your Honor?
Go ahead.
Judge, the objection isn't as to his knowledge, and you know what, we'll withdraw the objection.
Very well.
Let's move on. Judge, the next one, and let me just confer with my co-counsel for 1 second.
Go ahead.
Judge, the next one is page 318. Some messages between Charlie Adelson and Donna Adelson. Charlie Adelson's messages are hearsay, and they're not in furtherance of the conspiracy.
Response, State.
Yes, sir.
Hi, dog mama.
I could just give you the date of the messages too.
Go
The
ahead.
date is August 2nd, 2016, which is after the arrests of Secreto Garcia and Luis Rivera.
Student.
In the motion, defense also objected to this on the basis of joint defense privilege. Is that no longer being argued?
It's not that. The document we objected to on behalf of
Look at Georgia Kappelman just sitting there like a royal highness, surveying the landscape, listening to every argument, every nuance.
joint defense privilege is hold on, let me just double check.
Even Rashbaum's all over the place today. He's usually making a point of being trying to be pretty fluid in his delivery, but hold on, let me check. I don't know what I'm doing.
Is a different one, and we're going to withdraw that objection given the court's ruling earlier today.
Okay.
This doesn't have to do with that because it doesn't mention
This
Mr.
is just
Marcus.
hearsay. Okay.
This is just hearsay.
All right. So, Judge, on page 318, what we have are co-conspirator statements. This text message it says, this is from August of 2016, so this is going to be after the arrest of.
Hey, Kosher Style, listen to this. I'll tell you a secret. There is no fucking way Wendy Adelson is fleeing anywhere. She's, she's not surprised by any of this, and she's prepared, believe me.
Garcia and Rivera. It says, from Charlie Adelson to Donna Adelson. Did you see in the paper where the state star witness that rented the hotel room is a convicted cocaine dealer? Maybe those guys were just up in Tallahassee buying drugs and just in the wrong place at the wrong time. Maybe the coke dealer did it because Danny didn't pay for his drugs, just like he stiffed everybody else he did business with. This whole thing is just crazy. Then Donna Adelson goes on to say, I didn't see which paper. Charlie Adelson says, Tallahassee Democrat. Miss Adelson says, wow, I stopped reading everything. Charlie Adelson says, the guy admitted to selling them cocaine and hanging out with them. And Donna Adelson says, OMG, exclamation point. Our argument would be that this is co-conspirator statements. This is nothing more than co-conspirators celebrating another possible explanation that does not involve them for this crime. They are theorizing about another possible explanation for Dan Martell's murder. And this is showing just their theorizing and celebration of something that doesn't involve them that could explain the murder.
Any response?
I don't understand it. I mean, it is, I mean, I can show you the text messages in its entirety if you would like me to bring it up, but that's not what's happening. And I don't even.
I'll review it with my thumb drive as well when I go through the slide deck. The problem, Ms. Dugan, that I'm drawing with this, the communications do not have to be so overt as to saying, you know, we're hiding the gun here or something of that nature. But them essentially mocking, I guess, the drug dealer or the fact that someone else has been arrested in furtherance of their conspiracy. I guess flesh that one out for me a little bit more.
Well, also, I mean, their defense is that they were extorted, and this message pushes back on that. At the time this text was sent,
Don't
Garcia
speak over each other.
and Rivera.
What did Mr. Morris try and do to Sarah Dugan? Get back in your chair, Mr. Morris.
The defense is that they were extorted, and this message pushes back on that. At the time this text was sent,
Don't speak over each other.
Garcia and Rivera had been arrested already. So Donna and Charlie Adelson would have known the people behind Dan Martell's murder. And now those people are behind bars. And now, so why, if they've been extorted by these people for the past several years, why are they theorizing about another possible explanation for this murder? They know what happened to him. Those people have been extorting them for years and they're arrested. Why are they now trying to say maybe he was killed by a cocaine dealer for stiffing him? Why are they theorizing and celebrating something that doesn't involve them?
All right, so I follow your logic. You're not offering this for truth of the matter asserted, but rather to rebut any theory the defense is planning to present about a extortion conspiracy of some sort.
Right. Yeah, I'm not offering it to show that the state star witness was a cocaine dealer. Maybe Dan Martell was killed by a cocaine dealer, or that's what Charlie Adelson actually thought. It's to push back on extortion.
As to the basis of which it's being offered, Mr. Rauschbaum, what is your argument?
The key is you got to look, and I'm happy to hand up to you. You have to look at what Donna Adelson says. She doesn't say any of that. She's asking what paper, and I don't know what you're talking about. So it's Charlie Adelson's statements after the conspiracy, the alleged conspiracy, after the arrest, after the murder, and Donna Adelson doesn't respond in any way to what he's saying. She doesn't have a clue what he's talking about.
Right. As to this slide, I'm going to reserve for now. I cannot ask you to show your defense or what you plan to argue, but ultimately, if any way, if it comes down to your client was relying on the statements of Charlie Adelson in some way concerning her behaviors and how she conducted herself and whether she in fact knew of the extortion, if the state plans to rebut the extortion theory of the defense, it is permissible as to that basis, but not for the truth of the matter asserted. If a limiting instruction needs to be given, it will be given as to that specific slide. You may continue.
The next one, Your Honor, I don't have a page number. Let me see if I can figure it out. I think it's 321. It's very small writing, and it involves text messages between Donna Adelson and Wendy Adelson after Charlie Adelson's conviction. Again, the text messages by Donna Adelson are fair game, but the text messages by Wendy Adelson are hearsay. And the timing of it is critical. It's after the verdict. It's actually been hours after the verdict in Charlie Adelson's case. So I'm not sure how it could be in furtherance of the conspiracy.
Okay.
So I think that and we may be able to come to an agreement on this. I think that I'm going to, there's several messages between Wendy Adelson and Donna Adelson in this chain. I would only be using from when Donna Adelson says, prayer hands, we shouldn't have to pray. He's telling the truth. He protected his little sister for years. To your brother protected you for years, now you're not guilty. I wouldn't be offering anything after that. So I think the only thing Wendy Adelson says in the meantime is, I love you, call me if you can.
If that's all, then we're okay with that.
How about that? Let's move on.
The next one is page 324.
Hey, thanks so much, Derek, for your very generous coffee collection. 5 cups. Derek just got for us on buymeacoffee.com. Also, Anne-Marie, Marion, and someone just called someone. Thank you so much for the support, guys. Means the world.
So we can come to an agreement on this one too.
We're on a roll here. So you're not using.
Do we need me any further? Call it a day?
I'm not going to use that one in the presentation.
Okay.
I tried to give them all the things that I could possibly use and have tried to whittle it down some.
Just to be clear, that's the Cellbrite with the website pages.
I will be using the website page for the non-extradition countries, but not the motion.
Okay, we're good. That's all I have for now, Your Honor.
Very well.
On this issue.
As to slide 20, I will review the entire email.
Yes, he is.
Of course he is, with the shiniest shoes in the world, because when he's not out testing maps and testing the accuracy of the mapping software by driving the routes himself, he's at home polishing his shoes.
Go ahead and step down so we can take this.
Yeah, Rashbaum is certainly deflated. Who said that? Anne-Marie said Rashbaum isn't earning his fee today, is he? No, and that's one of his tells, you know. A bunch of stuff that he was dependent on has not gone his way, and now he is at sea when trial starts next week. I mean, this guy is the worst lawyer in the world. I'm amazed that that they've got him doing this. You're on trial for your life. You're a multi-millionaire, and this is the guy you hire. Why? Because he's a charming with the elderly. You know, did he bring some cakes for you to enjoy, you know, at one of your legal meetings? Muffins. There he is.
Sergeant, please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth? I do. You may take your seat.
Thank you, sir.
He's never told a lie in his life, this guy. Mr. Honest. Mr. Map, Mr. Honest.
Dugan, I will allow you to inquire. The only thing that I would ask is that you hit the points that essentially were at issue in the last hearing. If there's other examination you have for the sergeant, you certainly may get into that as well.
Okay.
You may inquire when you're ready.
Thank you. All right, Sergeant Corbett, can you?
Oh my God, we've got a live report of an earthquake going on in Los Angeles. Wow. Everybody get under a door frame. That's the only bit of advice I remember. Door frames. Now, abandon the stream. Neverly, darling, save yourself.
What's your name? Spell it for the record.
Certainly, it's Christopher Corbett, and that's Corbitt.
Okay. I know you've provided testimony a lot of times in this court, but just for the record, can you tell us where you work and what you do there?
Certainly, I'm a sergeant with the City of Tallahassee Police Department, and I supervise the technical operations unit.
Okay, and we're not going to be asking you for any opinions today, I don't believe, but just for the record, have you been qualified as an expert previously in the field of historical communication records analysis?
I have, yes.
And about how many times?
118.
Thank you. All right, so I want to go through a few different things that we see in your summary quickly, or types of things. One is going to be call detail record summaries. The next is going to be the plotting of location. The next is going to be, I want to touch on your routes, something that came up earlier today. And the next is going to be emails and texts. For summaries, in this case, did we receive phone records for Wendy Adelson, Charlie Adelson, Donna Adelson, Harvey Adelson, Sigfredo Garcia, Catherine McVanois, Louis Rivera?
Yes.
And did all of those phone records come from each party's respective carrier or phone company?
They did, yes.
Were each of them accompanied by a certification of business records?
They were, yes.
Are the phone records in this case voluminous?
Yes.
I mean, about how many pages are we talking about? Or just, I mean, hundreds, thousands, something like that, ballpark?
Ballpark is in the thousands. Just one set of records for Charlie Adelson is 4,400 pages, PDF pages. There's probably around 190,000 records that if you put to pages, approximately maybe 8,000. And that's, I think, on the low side.
In the summary that you prepared for the state and a copy which has been given to the defense, which is the same copy that you were deposed on a couple of weeks ago. In your summary, were you able to narrow the parties' communication events by focusing on what law enforcement sees as significant days in the planning and execution of this murder?
Yes, I was.
Now, in the presentation, do we see call detail records summaries of communication between the parties?
You do, yes.
All right, I'm going to mark this as states one. I've shown it to defense counsel. This is just is this an example of one of the slides that shows the call detail record summary?
Yes, it is.
Okay. And if I can publish to the court.
Is there any objection to this exhibit?
No, Your Honor.
It is admitted as a part of this motion hearing.
Thank you. All right, so in your presentation, do we see several call detail record summaries, just as we saw in Exhibit 1, throughout the presentation for the parties' communication on significant dates in the murder?
Yes.
All right, is Exhibit 1 an image of how those look?
Yes.
Is that how they look, though, when you get them from raw records from the phone company?
No.
What do you do to make them easier to read and put them in that format? How do you do that?
First and foremost is assembling all of them together into one database or one pool of information. We will assign names or subscribers to the numbers so that we can recognize which party is speaking with which party. We have to evaluate each of the events to determine if they are valid communication events.
Yeah, but Yendra, Rashbaum's new goatee is only covering one of his chins so far. I mean, he's sort of half in, half out. It's a little bit weird. I think he should do the whole thing or nothing. You know, pick a lane, man.
Or if there may be routing events or voicemail events, and those may or may not be included. We would remove duplicate events. In a summary like that, if two parties or two subjects are speaking to one another, we would have both of those events. From one party's record, it would be outbound, the others would be inbound. So we would eliminate one side of that so that we could show that it was one communication between the parties, and then it would be assembled in something that's much easier to understand and read, which is the format that you had in your exhibit.
After each one of those call summaries in the presentation, or after most of them rather, are there slides that show photos of the parties with arrows depicting the communication and then showing who communicated with who, the time that happened, and the amount of time they spent on the call?
Yes.
Okay, and what I'm going to show you, or what I'm showing you, I'll label as states 2. Is states 2 how those, an example of how those, I guess like a chart of the phone.
Sergeant Corbett's looking a little rugged today, right? He's usually so clean cut, but he kind of looks like a badass cop from a movie now, you know?
On communication looks in the summary.
Yes.
All right, at this time I move states 2 into evidence.
Any objection?
No objection.
States 2 is admitted at this time.
May I publish?
The cop in the movie that always has pure intentions but refuses to play by the rules, right? You know, good man, but you know, he makes his own policies.
To the court at this time.
You may.
Now this chart with the heads that has the data about the communications, are all of those charts that appear in the summary, are all of those based on the data that we see in States Exhibit 1, the call summary? So are they based on the call summaries for each of those specific charts?
They are based primarily on call summaries. Some of those would also include maybe text messages from another source, an iCloud return or a Cellbrite report. There may be calendar entries and things like that, primarily from the call detail summaries.
Okay, meaning that's going to track the communication, whether it be a text or an email.
Hello, Black Eagle.
That occurred between the parties.
That's correct.
And then you're saying that some of the charts with the heads and the arrows, when it contains the content of a text, that content would be from a Cellbrite report.
It could be, yes.
Okay. Regardless of whether it was from a Cellbrite or from the call detail records, is all of that communication in those charts from voluminous records, whether it be from a Cellbrite or from a call detail record from a phone company?
Yes.
For some of the communication events, I'm now going to move on to the location data. For some of the communication events in the call detail records that you told us about are these voluminous records from the cell phone companies. Were you able to determine location data for some of those events?
Yes.
All right. And I know you've given the court explanations in the past of how you do that. Judge, do we need to talk through that today?
Just briefly, so
Okay.
it's part of the record for the motion here.
Thank you. Would you give us a brief summary of how you do that?
How I determine locations?
From call detail records. Yes.
So the call detail records themselves will generally contain, for most events, the location information in the form of the cell site or cell tower that the handset is communicating with for that particular event. From that, either directly in the record.
Yeah, Corbett definitely looks a little less chirpy today, doesn't he? A little gray. Maybe we should send him a bottle of cinnamon sable hair dye or something. Maybe his wife's finally left him. You know, she gave him warning after warning, like, listen, buddy, What do you mean you've got to check some more maps this weekend? You said we were going to the lake. You know, and he just can't put them down. He's obsessed. You know, loves his work, but, you know, neglects his wife. Hope not. Hope she stands by. Maybe she's just as into maps as he is. Maybe they do it together. That's their thing. Date night, checking maps.
Records or from another key or cell site database, we would be able to determine the location of that cell site, where it physically is, plot that on a map, and then start to make some determinations about location. Generally, historical cell site analysis is about inclusion and exclusion.
Absolutely, Black Eagle. I think that's his color, cinnamon sable. You know, that'd take 10 years off him, I think.
Given locations, places, times, and ask if a handset could be consistent with being at that location based on the cell site that it's communicating with, or inconsistent with that location. In addition to the cell site, we're also generally provided a side or a sector of a cell site. Most of our cell sites are broken down into multiple sides. And so that helps us kind of further narrow down where a handset may or may not be.
How does your specialized training allow you to determine the location of a handset or the distance from a cell site of a handset that a layperson might not be able to?
There's obviously a significant amount that goes into that. First and foremost, locating the cell site, determining the accurate sector or side, determining the width of that sector or side, how many degrees or how far across on a clock, so to speak, that sector might cover. Evaluating adjacent cell sites or nearby cell sites to determine what the appropriate effective coverage area of that cell site may be, taking into consideration topography, buildings, bodies of water, other things that may affect that radio signal, and then again ultimately determining if I believe that a handset could have been at a particular location at a particular time.
When you determine, or when you are able to determine location of handsets, do you plot the cell sites on a map showing the cell sites, the time that the phone was communicating with that cell site, and the sector that they were communicating with?
Yes, sometimes we don't need to be as granular as the sector, and so sometimes we only plot the cell site itself. That may be good enough for the point, or there are times, yes, that we will indicate the sector as well.
Okay, and do we see those maps throughout your summary?
You do, yes.
All right. Do you use other things besides just call detail records to help you determine the location of a handset or who may be operating a handset at the time of a certain communication?
Yes.
Okay. In this case, did you use, let's start with, are there some examples of text in this case between the parties that helped you form an opinion on a party's location?
Yes.
Okay. Are some of those examples, if Charlie McVanois and Charlie Adelson and Catherine McVanois are making plans to meet up, and do you help, or do you look to that text message to help you determine their location when you then look at the call records and maybe see evidence of a meetup?
Yes, absolutely.
Okay. Or if you see a text message that says outside your house, can that help you determine a party's location when you're looking at the call detail records to see if their location is also consistent with being outside the person's house?
Yes.
In the summary, we also have, in addition to texts that have location data, we also have traffic tickets, car rental agreements, GPS pings of a rental car, Premier Jim still shot from footage, bank records of Rivera showing a picture of him at an ATM. I guess for some of those, I guess like a bank record, could that be part of a voluminous record as well?
Yes.
Some of those arguably not part of a voluminous record, like a traffic ticket or a rental car agreement. Would you agree with that?
Sure.
Okay. Why were those included though in your presentation? All those things that I just named, in addition to the text with location.
Again, the cell site analysis is about locations and times. So, for instance, the rental car agreement for the first rental car provides a location and a time. It's an address of the rental agency and a time that the car was rented. So this allows me to take that location and time and compare to the call detail records. I can look at the locations of the involved parties to determine who was present, who drove to the rental car location, who did not. The citation afterwards, the location of the citation tells me that Mr. Garcia was in a different location than Ms. Magbanua, because we don't have.
Thanks so much for the super sticker, Dilao. That's very kind of you, Dilao.
Mr. Garcia's cell site locations in that time frame. So the location of the traffic ticket helps me understand that after the rental, he went somewhere different than she did. Helps me understand that at the time of the rental, where other parties were. Mr. Rivera was still at his home. Mr. Adelson was nowhere near. So we can determine again who was present, because that rental agreement gives me that location and time to compare records to. It's also the type of event. So it's a, picking up of a rental car. And so as we look at the call detail records and who may be communicating with who in that time frame, understanding generally how car rentals are conducted, knowing that Mr. Rivera or Mr. Garcia ends up with the vehicle, Ms. Magbanua takes him out there, it's presumable that they're both in the car together heading to that event. So I don't expect really to see communications between them, nor I might not expect to see communications between Ms. Magbanua and Mr. Adelson, because she would be in the company of Mr. Garcia. And then I know the date and time that the rental actually happened, and I would from that deduce when they separated. And then I start to see communications from Ms. Magbanua to Mr. Adelson, because now, again, based on how a rental car generally happens, she has dropped him off, he has the vehicle, and now she will be by herself in the car and free to communicate. So all of that together goes into the analysis, if that helps.
Okay. Does the documents that you just spoke about, along with the other car rental agreement and traffic ticket, GPS ping, the Premier Gym footage, the ATM picture, do those documents help you determine cell phone location and help you form your opinion on where the cell phones are and who is using them, and put the communication around them for contact?
Yes, they're all locations and times that I can compare the records to. It's a validation of the records.
Can you believe that the defense is trying to get this guy thrown out for not being an expert? What? I mean, you could not get a guy that knows more about mapping technology and cell phone tower radio signals than Sergeant Corbett. He is the oracle of knowledge on these things, for fuck's sake.
Themselves, when I see someone in a picture or a video, I expect that their handset locations would be consistent with that. And if they're not, then there was an issue. In this case, they are consistent. So that's a validation of the records themselves. Yeah.
Okay. I was briefly going to touch on the routes, but now I'm remembering that objection was withdrawn. Is the court requiring any questioning on the software he uses to route? Okay, thank you.
You may lay any record, though, you think is necessary.
Okay. At this point, I don't think any is necessary, but if it comes up later, we can. Emails and texts are the next things I wanted to touch on. In your presentation, are there several emails involving statements by Donna Adelson?
Yes.
Yeah, and he's also the world's leading expert on emails.
All of the emails provided by Google, which is the company that Wendy Adelson and Donna Adelson use to service their email.
Yes.
Does that contain a business record certification?
It does, yes.
Now, why were the emails included in this presentation?
They were included to illustrate the content, and as far as potential motive or events that were occurring at particular times during the investigation.
Do the ones that were chosen involve Donna Adelson's interest in the custody battle and motive in this case?
Yes.
Are the amount of emails in this case from Google voluminous?
They are, yes.
About how many emails would you say that there are?
Wendy Adelson's account has over, I believe, 87,000 Donna Adelson's account is over, I believe, 57,000 individual emails.
Okay. And I'm just looking for a ballpark here. In your draft of your presentation, the same one you were deposed on, about how many emails did we send to defense's emails that these are of interest to us and we may use in your presentation?
No more than 25.
Okay. Since then, have we been able to kind of whittle those down to a smaller number?
Yes, we have.
Maybe 5 or 5 to 10?
Definitely less than 10, I think 5 or 6.
Okay. But despite how many we use in our presentation, are all of those from voluminous records?
They are, yes.
As far as, we also have several text messages in your presentation that don't have anything to do with location. Earlier I asked you about texts that had to do with location, like let's go to your house tonight or outside your house, things like that. Are there several texts in your presentation that are from Charlie Adelson's iCloud or the cell rights from the phones seized in this case that don't have anything to do with location?
Yes.
All right, not going to go through them all, but just some that are going to be included in your summary. Does some involve Donna Adelson's interest in Wendy Adelson's custody battle and venting to Charlie Adelson about that?
Yes.
Are there some that push back on a possible extortion defense?
Yes.
Are the total amount of text that we have in this case from Charlie Adelson's iCloud or from all of the parties' cell rights, are those voluminous?
They are, yes.
About how, ballpark, how many?
I believe from Miss Adelson's phone, there's over 10,000 WhatsApp chats, 20-some thousand instant messages. Charlie Adelson's iCloud account is, I believe, well over 280,000 messages. Another probably 10 or 20,000 text messages, kind of categorized separately. So we're in the hundreds of thousands of messages.
Okay. And thank you for clarifying that. So when I say text message, I mean any message communication as far as text, instant message, or WhatsApp. So thanks for clarifying that. And so that we've gone from, and how many would you say we've included?
Hi, Steve. Glad to have you here, man.
In your presentation to show the jury at this point?
I haven't counted. There may be less than 20 chats with, maybe, I would probably say less than 50 actual messages. But again, I have not tallied those up.
All right. But from tens of thousands to less than 50?
Yes.
Okay. And those are all speaking to specific issues in this case?
Correct.
Okay. Those are all my questions I have for him, Judge. If you wanted to, I can address any specific slide or document that you feel I didn't ask enough about that you need more of a record on. Okay, thank you.
Mr. Rauschbaum, do you have an examination for the witness?
Very, very briefly, Your Honor.
Yeah, very briefly. Very briefly, because he's going to walk all over me because he's such a great expert.
So, good morning.
Good morning.
So you testified that with regards to these detailed summaries, there's thousands and thousands of pages, right?
That's correct.
Okay. But on the days that you're using, so in other words, I think Ms. Dugan showed you Exhibit 2, where you're doing the arrows. On those days, if you look at the call summary, it's less than 5 pages, right? Mostly 2 pages on most of those days.
For those days, the summary that you have may be a page or 2 pages. It took a significantly greater number of pages to get down to those 1 or 2, because again, if there's 5 or 6 subjects in that one summary, well, that's 5 or 6 subjects worth of records. And they're records for a 3-day, 5-day period, maybe 20 pages each. So there's 100 pages to work down to get to just the unique communications that populate that 1 or 2 that's in the summary.
So let's get a little granular, okay? So you have one of those days is July 18, 2014.
Yes, sir.
Okay, and you do a summary of that day. if you took all your call records of that day, would it surprise you? All of them. If you took the call records for Charlie Adelson, everyone you got, would it surprise you that it's under 15 pages?
For one day to be under 15 pages, it would not surprise me.
Right. Well, I'm telling you, it's under 12 pages. Okay. That surprised you?
No.
Okay, so that's not that voluminous, right?
But that's 12 pages to get down to one. Right?
I get it, but I'm saying if you're putting in a document, in other words, if I use the emails as an example, or the text messages, Ms. Dugan brings up that there's 20,000 text messages, or actually 12,776 text messages. You can take my word for that. You're only using, though, let's say 8 text messages.
Oh, Daniel Rashbaum remembered a 5-digit number. Scary. He's prepared.
I don't know what you're using, but let's say it's 8. How long are those 8 text messages that you're using? They're less than a page, right, each?
They could be, yes.
Okay. The emails that you're using, you've got however number of emails you're using here. Wendy Adelson's email account had hundreds of thousands of emails, I presume, right?
Yes.
Okay, but each email that you're actually putting into evidence, do you know what the longest email is of the ones that you're putting into evidence in?
It would depend on how you format to print, probably not more than 4 to 6 pages.
Yeah, it's 6 pages, right? So the actual piece of evidence that's going to go back to the jury, which is the actual email, not the 100,000 irrelevant emails that no one cares about, but the actual document that's going to go back to the jury is 6 pages long, right?
I would agree with that, yes.
Right? So
yeah, man, we're not going to give the jury 100,000 irrelevant emails. What is your point?
We're talking about, and Ms. Dugan uses the word summaries, but these aren't summaries, right? These are just taking pieces of evidence that are already going to be in evidence and sticking it into a PowerPoint presentation, which is a way of persuading, right? A demonstrative, not a summary.
How is that not a summary? Like, here's all the evidence, and here's a PowerPoint presentation summarizing key points, take homes. And he's calling it a persuasion, not a summary. Way to make it sound sinister. It's concise information, Dan. It's ridiculous what these guys are coming up with.
I would object to argumentative.
Sustained.
Okay, I'll move on.
And that is the definition, ladies and gentlemen, of argumentative, which is kind of hard to understand, but I think I've got it down, you know, in terms of what it means in terms of an objection. We should discuss that later. We should go through all the different objections and make sure we've got them locked down.
With the location data that you're talking about, just centering on Donna Adelson, and I don't know if you have your records up there, so I'll just show you a page. Okay, and we can mark this as defense.
Yeah, Rashbaum loves to show his peacock feathers to Donna. You know, look at me, Donna. Check out my plumage. Check out my plumage. Ruffle my feathers.
Exhibit 1 for purposes of this hearing. This is page 271 of my version of your exchange.
And again, Kerry, this is exactly like Daniel Rashbaum's only drive is not to achieve the goal of what he's been paid to do, but to achieve his own goal of convincing his client that he's done a good job. Right? That's his own. That's all. We went through the whole Daniel Rashbaum closing argument the other day for Charlie Adelson's case. Check it out on our channel page if you missed it. That's all he was doing, and not even for his client as Charlie, but Donna. Impressing Donna. That's all he does. Check out my plumage.
You'll know this.
Yes, sir.
Okay. Judge, may I approach?
Right.
So your expertise in doing this page, am I right that what you're basically doing is you're taking Donna Adelson's call record, you're seeing when there's an event, you're looking at what location on the call record the event hits. You're then going to a map that AT&T provides you, because it's AT&T in this case. You're then looking what the longitude and latitude is on that map, and then you're just plugging it on that piece of paper, right?
That is part of what I do, yes.
On that piece of paper, is that what you did?
Yeah, you just say the Sergeant.
No, I don't. Thank you, sir. Again, to start that, I have to go through, and this is combined. This is Donna Adelson and Harvey Adelson's records. So it's two sets of records. So I go through the records to find the relevant time frame, and there's 3 data sets for each.
Neverly Darling, a plumage is defined as a bird's feathers, collectively speaking, a group of feathers.
Each set of records. There's voice calls, there's data sessions, and there's text messages. So I isolate out each of those 3 data sets for the 2 sets of records. And then I have to evaluate those records for what I consider to be valid location information. And so a number of records are eliminated based on my understanding and knowledge of AT&T records. A lot of those locations are eliminated so that I have valid locations to plot. So from that, each of the locations in the records have to be verified against a records key or some other database for me to make sure that the information provided in the records is accurate. And then that is plotted on.
Yeah, right. Derek, who says, imagine your freedom depending on Daniel Rashbaum's legal skills. If I was Donna right now, I'd be making notes for my appeal of ineffective assistance of counsel. You know, I mean, Jesus Christ. What a bumble. He's just a total bumble, feather bumble.
Onto a map. And then from that, some estimation or determination about where the handset was during those events can be made.
Okay, let's try to simplify that. I know you like to make it a little bit more complicated than it is, but
Don't lay it on Sergeant Corbett, Rashbaum. Get back in your box, man. I know you like to make it complicated for my tiny brain, but let's straighten this out right now.
when you say you eliminate events, you eliminate them, for instance, when it says 0 seconds, correct?
0 seconds could be a factor.
Right. Why else do you eliminate? What duplicates, right?
Dan Bailey, we've got some great Georgia Kappelman merch coming in the pipeline. And yes, she is the epitome of desire for many of us.
Location information, the duration may play into the validity of data sessions. In particular, with these records at that particular time, not all the locations contained in the data sessions are accurate at the time. So I have to go in and evaluate each one of those to make sure that they are the correct usable locations for that. And I guess I'm not the one to determine how much expertise that takes, but I believe that it certainly requires it.
Well, on that piece of paper, which is all Donna Adelson's, everyone that relates to Donna Adelson looks like that. Okay. So
I know, Mr. Pinto Peabody, right? I mean, what the number one quality that you do not want in a lawyer is when they have the ability to just make you drift off. Every time I listen to any extended verbal argument presentation by Daniel Rashbaum, I'm asleep in about 1 minute. And then I try and pick it back up, don't know where I am. I need Sergeant Corbett to pinpoint it on a map. You know, it's ridiculous. You need GPS to follow Daniel Rashbaum.
So on that piece of paper, would it surprise you that all you needed to do for that piece
I
of
would
paper?
object to relevance to what would surprise him.
Okay.
Please
I'll rephrase it. On that piece of paper, you can see those times directly on either Harvey Adelson or Donna Adelson's chart. You see a call or a text message.
Yes.
You go and you look at what time it is, right? It says 8:15 next to the call.
Correct.
And then to the right of it, it gives you a longitude and latitude.
It does.
For each of these. And then you take it.
Well, he's about the same height as a 6-year-old riding shotgun, so that fits.
AT&T map, and you plug in that longitude and latitude, which is what you did, right?
Well, I don't take an AT&T map. I take the mapping software that we use, the Esri mapping.
Fair enough. You plug in that longitude and latitude, and it spits out a point to put a dot on a map, right?
It does.
And so even though it can be difficult, I'm not saying that there aren't examples that are difficult. In the ones that you're doing for Donna Adelson, it's on these pages. It's as simple as that. It's as simple as looking at the data, plotting it in, and doing dots.
Again, I don't know that I'm the one to quantify what is simple or difficult, but I will tell you that if you took her records and you plotted every event in that time frame, you would be plotting some incorrect locations. So it at least requires the recognition of valid locations at the very minimum.
So tell me, on that piece of paper, what events were invalid that you got rid of? Because I don't think there were any invalid on that piece of paper. I don't think there are any other cell site data that showed up. I think those are the only ones that showed up.
In that sequence, that travel sequence in those
Tell me
period
what you eliminated.
time, there are a number of data.
Yeah, Derek, I was just thinking that maybe the Ambien people will approach Daniel Rashbaum to be like, you know, the main guy, the poster boy for selling their pills. But the thing is that he'd actually put them out of business. If you listen to Daniel Rashbaum's closing argument, what do you need Ambien for? You'll already be asleep.
Sessions, and I would have to be looking at the records themselves that are continuous data sessions. And so they show locations, particularly from Mr. Adelson's cell phone, as I recall, of data sessions that originated at his office. And those data sessions continue to show the original location, even though the times increase. And so
You're talking about Charles Adelson.
I'm talking about Harvey Adelson.
It showed him at his office on that day?
It did, yes.
On July 18th?
As I recall, that
Are you sure about that?
I don't want to say office. There are, if I can look at the records, there are data sessions that originated earlier in the day that continue to show the original location.
Okay, let me ask you a more simple question. On the actual exhibit that you're using, which starts at 8:15, I think, it plots, I think, 4 locations. On those 4 locations, were there anything that you had to eliminate in between those 4 data points?
I don't recall specifically. I can look at the records and tell you, but I do not recall if there were other things.
Well,
in
do you
that
have the
time.
records in front of you?
I have my laptop. I can pull them up. It will take a minute, but
Sure.
Go ahead.
Judge Everett wants to see the laptop.
Judge, while he's getting his computer out, the court, my memory serves me, it seems like this line of questioning is Mr. Ashbaum's trying to inquire into his level of expertise and why does it require an expert to do this type of work. Did the court already, I believe the court already ruled at our last hearing that he would be able to testify as an expert, form an opinion as to locations of cell phones, all of the things we would be offering him for in that purpose.
That ruling was made. Ultimately, is this going to an opinion that he is not permitted to give in some way, Mr. Rashbaum?
No, I mean, I'm trying to show that there's no expertise in these particular documents. There might be in showing where Sigfredo Garcia's timepiece was, but that there is an expertise with regards to Donna Adelson's. And I'm using this to show that the documents that he has chosen here, or that the state has chosen for him, that it's a demonstrative. It's not a summary exhibit as iterated under the Florida statutes. Again, we're not arguing that the demonstrative can't be used, and we're not arguing that the underlying documents can't come in. We're arguing that his presentation is not a proper summary, but is rather a closing argument that shouldn't go back to the jury.
As to that point, I'll permit it, but let's not have a full cross-examination of the witness that goes beyond the issues as to the admission of the evidence.
Fair enough, Your Honor. Sergeant Corbett, if it's difficult to pull up, we can move on to.
Not difficult. It will be a little time consuming again.
Let's move on. I think we've made the point. Sergeant Corbett, these emails and these text messages that you pulled, how were they chosen? Did you choose them?
I did not choose them, no.
Who chose them for you?
They were ultimately chosen by the state attorney's office.
May I have one moment, Your Honor?
Go ahead.
Ooh, they were chosen by the state attorney's office. Well, yeah, they're the ones prosecuting the case.
I have no further questions.
Going to redirect examination for the sergeant.
No, sir.
You may step down, sir.
Thanks, sir.
In addition to the argument that was made at the previous hearing, does either party have any additional argument to offer before the court rules?
Very briefly. Or did you want the?
Whoever's ready. You are the proponent, Ms. Dugan, so you get the first crack.
All right, so we heard about several different types of items that are in the summary. The first is the summary of CDRs, an example of states one. We heard that those are pulled from voluminous business records for certain periods of time. Then we saw the charts that are basically a visual depiction of that communication that's in a film, but in a more digestible format for the jury. It's based on data from those call detail records, from the voluminous business records, and also from voluminous records in the Cellbrite. The only thing in the chart that is from Cellbrites would just be some charts have contents of text messages in there. All the rest are going to be calls back and forth with the time and the person making the call, the person receiving the call. But all of that information is based on the data, and we can't just give the jury all of these cell phone records and say, even if a certain day is 16 pages across 3 sets of records, and say, good luck. That's why the summary.
Many thanks, Amanda Chapman, who just bought us 5 cups of coffee on buymeacoffee.com. That's very generous of you, Amanda, and we really, really appreciate it. Good day to you, ma'am.
Rule allows us to pull this information, put it together in a digestible format for the jury. The second type are the maps with the cell site locations. These are summaries of the parties' locations at certain times that are also pulled from the voluminous cell phone records. The same records that the call detail record summaries and the charts with the heads are pulled from. Other items like the premiered surveillance footage, the tickets, the texts that talk about a person's location, the bank records, the car rental agreements. All of those things are in the summary because they help Sergeant Corbett form an opinion on who had the handset at the time and where that handset was located. And they help verify the call detail records themselves. Finally, we heard about emails and text messages. The emails are business records from Google. These are voluminous records. They're being testified to by a sergeant who specializes in communication records. He has identified and verified these as being from these accounts. There are thousands of emails. We found several emails, lots of emails that go to motive or go to the interest in the custody battle here. We're going to be using about a handful in the presentation. The same with the text. These are maybe 50 texts narrowed down from hundreds and thousands that show certain relevant issues from this case, whether it be pushback on extortion or other things. And these are all pulled, though, the emails and the texts that aren't location data is what I'm talking about. They're all pulled from voluminous records, and they're all a summary of evidence showing a relevant issue from those voluminous records. Thanks.
Thank you. Mr. Rashbaum.
Yeah, definitely voluminous records, right? Thousands. And what did he say? The one from Charlie Adelson is 8,000 pages. Wow.
Judge, you've seen their summary. Their summary is a closing argument. It's not a summary. It's a demonstrative. Our ask here is not a big ask.
It's a summary of facts, you douche. technicalities. That's all they've got. You notice that they haven't spent 1 second arguing anything about all of the evidence. It's just like, that you can't put that in because that's a persuasion. That they're trying to persuade the jury, Your Honor. Well, yes, it's a trial.
The underlying exhibits are going to go to the jury. They're not voluminous. The fact that there is a universe of text messages and they've chosen 10, 15, or 20 of them does not mean that they can make a summary of it.
Your Honor, we want to overwhelm the jury and bury the relevant information in 100,000 emails. Okay? It's like find the evidence. Instead of the Easter eggs, it's find the evidence. We give the jury 30 minutes and they scatter and look for the evidence in the 100,000 emails. Needle in a haystack. That's what we want to do.
That's not how the rule works. They can put in the text messages, none of which, not one text message is voluminous in this case. Not one email is voluminous in this case. And by the way, the call records aren't voluminous because what they're going to put into evidence are they're going to put in the overall call records, and then they can put in, if they want, a subset of the call records. For instance, July 18th. They can put in those call records. They're literally less than 12 pages. Now, we're not suggesting that Sergeant Corbett cannot have a demonstrative that illustrates the issue, but to allow a 320-page document or whatever it's going to turn out to be, which is purely argumentative. I mean, they're taking text messages and homes and cell locations, and they're all making an argument of what it means, is precisely what the court in Pete Incorporated v. Vanguard 378 F. 3rd 1154 cautioned against. When it said, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence, care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. That's what they're doing here, Your Honor. They're putting a closing argument. They're trying to put his demonstrative as a summary exhibit of a closing argument to go back to the jury. That shouldn't be allowed. And so, Judge, we're not asking that a demonstrative not be used. We're not asking that the underlying documents don't come in, but we're asking that the exhibit be a demonstrative exhibit, that does not go back to the jury.
May I briefly respond, Judge?
So briefly, it will tickle my ears and we'll move on. Go ahead.
There is no argument in any of these slides. This is all data and information from the records. There's plenty of evidence in this case that is not in this presentation that would be in a closing argument demonstrative. This is not a closing argument demonstrative.
Judge, may I briefly respond?
Let me set my watch. It's 11:02 and 32 seconds. By 11:03, you will be done.
Argument is when.
How much class does Judge Everett have? Let me set my watch. It's 11:02 and 33 seconds. By 11:03, you will be done. I'm listening to that again.
It's not in this presentation that would be in a closing argument demonstrative. This is not a closing argument demonstrative.
Judge, may I briefly respond?
Let me set my watch. It's 11:02 and 32 seconds. By 11:03, you will be done.
Argument is when you plot lines on a map and then you take a text message and you put it next to a house and you put it all together. That's argument. That's using data to make an argument. That is the definition of argument.
Within time. Thank you.
Your Honor.
All right. As to the rulings on this matter, the court has previously ruled that Sergeant Corbett can be qualified to testify to the interpretation of historic communication data. The summary will be available to the state as a demonstrative in front of the jury. Also, in researching this matter, I came across a recent case of the 3rd DCA dealing with summaries, which I believe has a relevant ruling to this matter. This is EJD Construction Contractors and Investment Corporation versus Preston, found at 306 Southern 3rd, 1053. And ultimately, the third DCA held when a summary is accurate and not misleading, it can be properly admitted during trial. The summary may also include opinions by the individual preparing the summary, as long as the opinion is based on the underlying evidence and data that is admissible. To that point, the court will permit a summary to be admitted to the jury. However, the summary may include a page cross-referencing all voluminous records or state exhibits that Sergeant Corbett used in forming his opinion, his method of analysis, and the conclusions that he reached, or any inferences which may be properly drawn from the evidence. The summary is not to include any cumulative repetition of admitted state exhibits, and this is specifically going to matters such as emails, text messages, videos, things of that nature, any inadmissible information, or any opinion the witness is not qualified to give. This is going to cut down the pages that actually go back to the jury, but a summary that is based on the voluminous records and exhibits and the opinion that was reached by the sergeant that is proper and meets the definition of a summary pursuant to 90.956 will be.
Oh, you mean it's not a persuasion, Judge Everett? This is a persuasion. It's not a summary. It is the definition of a persuasion, Judge Everett.
Any additional objection that needs to be raised at the time it is offered, the defense may raise at that point. Do the parties need any clarification on the ruling?
No, sir.
And just so it's clear, as far as the call record summaries, and I believe the arrow charts, the location maps, that will be permitted as well. But again, all of the other matters that are not voluminous themselves, such as any emails, text messages, or videos, it can be cross-referenced as to what the sergeant used, but it will not be a part of what is admitted. The demonstrative itself, though, can be used as the state would like to use it. Ultimately, for that, if there are any inadmissible items that still need to be ruled upon, I believe slide 20 is the only one outstanding. I will give you a ruling on that matter before it is to be used even as the demonstrative. There are no questions. We are finished at this time. I will see everyone on Tuesday morning at 8:30, and we will begin with the jury selection process. The process will be, as we did in the last trial, going through the same 5 questions dealing with pretrial publicity and any hardship. The parties will be permitted to examine the prospective jurors based on the court's questioning. Anything that we need to address before we finish?
Judge, there is just one scheduling issue.
Go ahead.
And look, maybe trial will go quicker. I'm hoping it does, but based on what I'm seeing, October 3rd is Rosh Hashanah, the Jewish holiday. And I just want to see.
I believe the court is closed on that day.
Perfect. And I'll sit down now.
I'm not going to make you work on a holiday, Mr. Rajabov. Yes, ma'am.
He could have looked that up, huh? If he's so fucking concerned about it. The court is closed, dickhead. What is it called? Rosh Hashanah. Any Jewish people in the chat? Can you confirm the spelling of that Jewish holiday?
For Monday, let me go through that then based on the chart that I have in land. If it's not related to those, then we're just going to finish up. We are in recess at this time. Have a good day, everyone.
So Corbett's coming in, Donna, with his maps and his cell tower dumps and his emails. Wow, that was pretty good, man. Is anyone else feeling the pressure coming? We got 2 more working days before we're straight into... Oh. Georgia Kappelman's a beauty in blue today, folks. Look at her, all chained up like a bear. Do you think they needed to find an extra large chain to wrap her? Ah, Rosh Hashanah. Okay. Rosh Hashanah. Yes.
This is going back to you.
Check out the patchwork. Wow. That top looks like the foyer of a 1980s Holiday Inn, the wallpaper.
This is going back to you.
Oh, thank you so much. Put this in here before I...
Well, that was great. That was a really good one. That was the best hearing yet. Jury selection next Tuesday. No deal, Donna. No deal for Donna. You're diving straight in with both feet. Straight into a cell. But it's not over yet, guys. But after seeing Rashbaum and scalp in this motion, my God. I wouldn't be holding on to much hope if I were Donna after that. I was kind of wondering last week when we saw Dashcam running up and down like a baboon, like a wild, horny baboon at the zoo. Yep, they know how to have all kinds of fun without a date. Yeah. Well, it's Paul. Good to see you, Paul M. Yeah. So long, Donna, huh? Okay, guys, we have got to shut it off now. We've got to do a few other things. We might be back this evening, depending on these battery charges. Yeah, we'll see how that goes. Hopefully, we'll be back this evening with some. What were we going to do? Possibly some multi-trial Luis Rivera analysis. I've also got to get my theory out quickly about the Uvia dinner. I think other people are starting to mention it, and I was the first one, and you all know that because you've been here. But yeah, I'm not one of those guys. I don't need to say I was first, even though I was. Yeah. Maybe we'll do that one on the weekend, though. So we'll have to play it by ear, but I'll put a notification up on the channel if we're going ahead tonight. And apart from that, we will see you all later. Have a good day at work, everybody. Try to focus on stuff in your working day now. That's it. We're going to trial, jury selection, Daniel Rashbaum, Scalp Rash, Team Scalp Rash. We're going to be looking for all kinds of sympathy harboring jurors to come and sit and let the old lady go back to Miami and play shuffleboard. Yeah, special thanks to everybody and all the contributors. Fantastic work, guys. Team Zazu is here to stay. Yeah, okay. Signing off. Be kind to each other. Don't be an Adelson, and have a safe drive to wherever you're going. And watch out for those earthquakes, California. Remember, door frames. Door frames are your friend. Later, guys.